Hey everyone, Ali here. So we are ready to do our employment law update for 2024. Such a crazy time as has been for the last 4 years. We are seeing a lot of changes, and so we're going to change things up a little bit today because we are going to talk a little bit more about some of the federal changes that are happening, and then talk a little bit about the state changes. The reason I say we're going to change it up a little bit is because historically, at least the last couple of years, it's been mostly state law changes that have happened, but there's been a lot of federal things that have happened as well. And so we're going to go through all this in detail in the next half an hour or so, 40 minutes, and then leave time if you guys want to submit questions and things of that nature. You can do that. And we'll probably handle those questions offline because typically we get a lot of questions, and that's okay. That's good. That's what we want. But we will contact you directly, after that. But as most of you know, HR compliance is not a nice to have, but it's really a must have. And it's something that we are seeing become more and more problematic, across the country in all the states. And the reason is because like we talked about, the federal level, at the state level, things are changing. And although many of you used to ignore some of these rule changes because you didn't think it would apply to you, the reality is that these laws now apply to everyone, of course, but more importantly, they are ripe with potential problems, because if you don't do all these new rules, then you're going to be hit with a ton of penalties and fines and other similar type of things. And so we're going to avoid all this. Most of you know, but for those of you who I haven't had the pleasure of meeting yet, my name's Ali Oromchian. I'm the CEO of HR for Health and an attorney at Dental and Medical Council. Our firm and HR for Health focus on helping doctors in all different facets of their businesses. So whether it's buying practices, selling practices, and all that stuff, we handle partnerships and things of that nature. And of course, at HR for Health, our primary focus is to make sure that you are HR compliant from A to Z. So our software helps you make sure that you have all your new hire documents, your employment manual, your clocking in and clocking out correctly, payroll, and everything else in between, which we can always talk about, at a later point. So here's our agenda for today. We're going to talk about federal law changes, state law changes, like we talked about, how these things implicate your practice and what you need to do to, get compliant quickly as to avoid any potential problems like we talked about. So right off the bat, let's talk about something called the Patient-Centered Outcomes Research Institute fee. It's a mouthful for sure, but it's a fee or tax on health insurance plan sponsors and issuers that's supposed to help fund, better patient outcomes. Now, this was established by the ACA back in 2012, and most of you are probably thinking to yourself, what is this? I haven't ever paid a fee like this. Why do I have to pay a fee like this? And I'll tell you, for most of you who are listening today, this is probably not something you have to worry about, but it is something we get a lot of questions about because it is out there on the news. It is out there with various articles and things. So the PCORI fee is imposed on an issuer of a specific health insurance policy. So we're talking about the biggest health insurance providers out there, or plan sponsors who have their own self-insured health plan. Now, this is where it may be applicable to you. If you are or have a self-insured health plan, okay, a self-insured health plan, then you are in essence stepping into the shoes of one of these large health insurance plans out there. And so as a result, you may end up having to pay this fee. Okay, and so the fee is basically $3.22 multiplied by the average number of people that you've got covered under your policy. There's a whole IRS notice about it. Again, for most of you, probably 90% of you, who you don't have to worry about this because you have your health insurance group plan through an issuer, right, through another health insurance company. But if you are a large group or large practice, DSO, MSO, and you have your own self-insured health plan, then this is something that you've got to be aware of. So just kind of keep that in mind. Okay, next, let's move on to the EEOC's enforcement guideline with regard to harassment. Basically, what they did was the federal government saw that they had all these, different guidance documents on all kinds of harassment that exist out there. And they wanted to make it simple. So they, in April, combined all of these 5 guidance documents that went back all the way to 1987 and consolidated it into one resource, right? One unified place where you have all of these protections and then additional protections that that may not have been in existence in those 5 other things, like, for example, LGBTQ plus workers. There's information about remote work employees and what happens there. There's a lot of stuff between religious freedoms and harassment and what that means. Outing an employee, without their permission, whether, because they're same sex or because they're transitioning or anything else, that falls into these new rules. Misgendering someone, and related to that, refusing or intentionally using the wrong pronouns if someone is either transitioning or they just wish to use a different pronoun. Those kinds of things are dealt with in this. Denying bathroom access because of gender identity. All these things are now documented in this new document. And what's important to keep in mind is that this is a pretty it's a really good document because it does simplify things. Now, some of you may or may not agree with some of these rules, of course, I understand that. But, at the end of the day, this helps create a balance between, protecting workers from harassment and then giving guidance on employers on how to accommodate these employees to avoid any liabilities. Whether or not you agree with it or not is really beside the point, because this is the law of our nation and we have to abide by it, especially since a lot of these rules are now federal rules. But how do we avoid this? Well, it's important to review this document and then maintaining clear, concise, easy to understand policies. Hugely important, right? Hugely important. If you feel like your employment manual is not concise, if you feel like it's confusing, then just contact HR for help, and we will make sure you have these really incredible plain English type of policies. And then it will help you implement these things in a safe and effective way, so that if someone, God forbid, has an issue in your office and they need to report another employee, a manager, the owner, maybe a vendor, maybe a patient. Sometimes we forget that harassment can be done not just by the team, but also by vendors. It could be done by patients and others. And so it's really important to have like a reporting procedure in place. And the document kind of goes through all of that. And then, if you do all of those things, plus you have some training, for all the employees and managers, then you should be in really, really good shape. And so important to kind of keep this in mind. Now, you might say, and a lot of people are asking, well, why is this document important? Well, we went through some of this just a second ago, regarding why it's important. But if I had to break it down, I would tell you it provides clarity, right? Standards for preventing and addressing harassment. I mean, I think that is their number one goal. And it's nice that they were able to combine all these, different guidances, because it was very confusing. I mean, it was confusing for experts like us, let alone for you when you are busy running your dental, medical, optometry, vet practice, and you just have, no time to kind of go through this stuff. So this definitely clarifies that. It provides broader protections, to certain employees that have been historically victims of harassment or whatnot. And then it also serves as a guide to ensure that you're compliant, so that if somebody does complain and you've done all these things correctly, well, then you're off on the right foot. But remember, it's not enough just to look at this or have it. Important to update your policies in your manual, review them, implement them, issue them, have the employees sign them. Hugely important. And of course, if you are already an HR for Health client, you know that you're enjoying these sort of automatically law updates in your employment manual and other things. And by having that, you don't have to worry so much about making sure your handbook's up to date, because we're updating it for you. If you're not an HR for Health client, then it's super important that you start looking at these things, right? These things. All right, the next thing is we're going to talk about something that has been a little bit confusing, because we are getting a lot of inbound calls about this, which is the new Department of Labor's overtime regulation. Now, typically overtime has been handled, at the federal level, nationally, but a lot of states have their own rules, right? Some states, like California, have overtime rules that are that start when someone goes over 8 hours in a day or 40 hours in a week. Some states have it if somebody goes over 40 hours only, and there's a couple of different variations of these. But the government wanted to kind of make this a little bit more streamlined across the country. And so what they did is a rule that goes into effect, or went into effect on July 1st, basically increases the standard salary level that helps define someone being exempt from overtime. What that means is that to be exempt from overtime, you have to fit into some categories, right? You have to either be, a professional, you have to be, a manager, sometimes have administrative duties. There are exceptions, categories that you have to fall into to be exempt. But there's different requirements, right? It's not enough that you're just a professional, right? A doctor. That doesn't make you exempt. You also have to fit into a minimum salary. Now, historically, that number has been lower. Now, starting July 1st, the minimum salary for someone to be exempt, from a per week perspective, is $844, right? So they have to make at least $844 a week to be exempt. On January 1 of 2025, that's going to go up to $1,128. Okay, so again, you would have to fit. You have to be above that, plus fit into the duties test to be exempt, right? So if you are someone who's, let's say, an office manager and you're making less than $844 per week right now, you cannot be exempt, right? You cannot be exempt. Now, there are some highly compensated employees, right, that have a sort of a slightly different test. And what that means is that you have to be above a certain minimum salary test, right? A minimum salary test. And it's very important to know what that is, right? So the rule will increase the total annual compensation requirement for these highly compensated employees. So from $107,000 per year to $132,000 as of July 1st, 2024. Okay, so that means that if you're a highly compensated employee, you're a doctor associate, and you're trying to fit into the exempt status of overtime, you had to be $107,000 or more. Now you have to be $132,000 or more. It's almost $133,000 to be quite honest. It's $132,964. So just use $133,000. And as of January 1, 2025, that's going to go up to $151,000 or more. So again, these are the salary level test for the exempt versus non-exempt status. And so this, if you guys want to take a screenshot of this, This is sort of just an easy chart to see what we were just talking about, with regard to non-highly compensated employees. So this is, everyone else in the office that may or may not be exempt. Currently, it's 600, or it was 684,000 as of July 1st. It became $844 a week. Then, as of January 1, 2025, it's now $1,128. Okay. All right. So, what do you do? Now that you have this information, well, you've got to look at your team's salaries and see, is there anybody that you are not paying overtime to, you're not giving lunches and breaks to, meaning you're characterizing them as being exempt from those things. And you have to see, one, it's always good to just double check, do they fit the job test, in terms of the duties, does that fit correctly? And then also, what is their salary like? Does it fit this exempt status that we talked about? If it does, then great. If it doesn't, then you absolutely have to make adjustments by either starting to pay them overtime, which is obviously the easier way of doing it, or you can increase their compensation above the minimum. Okay, above the minimum. All right, let's switch gears a little bit. Something that everyone has heard about, the Federal Trade Commission's ban on non-compete. Again, the federal government is getting, really heavy-handed into our businesses, and they're basically saying that any employee across the country can compete against their employer and can get up and move and work somewhere else, and there's no real restrictions. Now, it goes into effect 120 days after the publication in the Federal Registry, which basically puts this at September 4th, 2024. That being said, there's a whole bunch of lawsuits happening across the country regarding this, and a couple of states have, put the kibosh on it temporarily, where the judge, seeing the case, has basically said, look, we're going to table this law until we figure out whether or not it's legal and whether the FTC had the power to do it and things of that nature. And so if you have any questions about this, whether it's legal in your state, whether it's allowed, just let us know and we can tell you whether in your state the judge has put a stop to it, or whether it's moving forward until the Supreme Court, rules on it one day. That being said, this is not going to change the law in some states. Okay, so some states, like, again, we'll use California as an example, non-competes have been wholly unlawful for like generations. And so this rule doesn't do anything because it's already illegal in a state like California where you can't have non-competes. But in other states, where non-competes, are allowed and it's not unlawful, then, or maybe they're slightly, restricted, but again, they're not totally unlawful, then the law does apply in those states, unless, of course, as I mentioned, a federal judge or, has put a stop on it while, hearing the case and whatnot. And so if that's the case, then, it may or may not, apply in your state. That all being said, although I think we all hope and wish that, this law, go away, so that we can prevent, our doctor associates from leaving and opening up, an office, a couple doors down or down the street or whatnot. The reality is that, the law is going to probably stay, and it may not look exactly this way, but it is going to probably, feel very similar to what we're seeing. Because even if it gets struck down by, let's say, the Supreme Court, Congress can, of course, come in and pass the law, as opposed to the FTC. Congress can pass the law, and then it becomes the law of the land. And so, please keep that in mind. The wave is for laws like this to remain on the books. And so, even though it's not ideal as a business owner, the reality is that it's probably here to stay. And yes, you will face, sadly, higher rates of employee turnover, especially with doctor associates. and that may impact patient care. It may impact, patients staying with your practice. It may decrease patient satisfaction because their provider has changed, and of course, patients could always leave to go to another competitor or to the doctor who's leaving. But the reality is that this is most likely gonna stay. There are ways of combating some of this, through potentially higher pay, better benefits, and things of that nature. And those, if anybody wants to kind of explore some of those, let us know. There are some good consultants that can help you create packages and other things that might be helpful. Okay. All right. Let's switch gears now to the states because there are a lot of new state laws as well. Obviously, we can't go through all the state laws, but we can go through some of the more major ones. In California, SB 525 was passed last October. That basically increased the minimum wage, and it's going to slowly increase them, over the next, many years. And so it's important to keep a couple of things in mind. One is that, there's a lot of talk about this $25 minimum, hourly rate for healthcare workers. And, what is a healthcare, facility, where this applies? Does it apply to dental practices, optometry practices, and so on and so forth? And the answer is basically no. When we talk about a covered healthcare facility where this $25 per hour salary applies to, we're talking about hospitals. We're talking about tribal clinics, outpatient centers operated by the federal government. Those are the kinds of facilities that we're referring to. Physicians, nurses, clerical workers, janitors, all those in those scenarios, it applies to them. But this $25 an hour minimum does not apply to dental practices, optometry practices, and so don't worry about that. I know there's a lot of information out there about this where people are freaking out and saying, oh my gosh, do I have to, increase my receptions to $25 an hour? But the answer is no. And so, just kind of keep that in mind. If you have questions about this, let us know. Now, the minimum wage has increased, throughout the state of California. In some counties are even higher, but they're not at $25. Now, the reason why this is important is because, again, your payroll companies that you're using are not HR companies. Even though some of them say they do HR, they don't, right? They don't. And the reason they don't is because they're not keeping an eye on certain things. We've had numerous clients, get in trouble this year since January 1 because, minimum wage increased and their salaries, or not salaries, but the hourly rates of their employees did not increase. And so the payroll companies didn't tell them. The employees find out at some point and then go complain to the state. So again, hugely problematic, and really no reason for that. But again, just remember that what payroll companies do just that. They run payroll. They don't do all this other stuff that's more HR compliant-esque. Okay. All right. The next thing is, we get a lot of questions about this, but we don't do this ourselves, at HR for Health, which is, this workplace violence prevention plans. Effective July 1, California requires employers, almost every employer, to establish and implement and maintain this detailed workplace violence prevention plan. And a log that goes with it. They have to, employers have to meet this requirement. They have to meet this training requirement and documentation. It's super important. If you want to put one in place, HR for Health does not provide that. But one of our partners, it's a company called Abide. does provide it, has a wonderful program. You can scan it with your phone or scan that QR code on your screen with your phone, and it'll take you to a document we've jointly created that gives you more information about it. It's a guide, and it helps you kind of get the process started. And of course, Abide and a couple of other companies do a really great job of giving you this actual plan itself. And so if you need that, you can contact them. You can contact a couple of other companies, and they'll do it for you as well. Okay. All right. Let's go to Colorado Job Application Fairness Act. This now prohibits employers from requesting age-related information on job applications. This has been happening nationwide in a lot of states, but on July 1, Colorado, has joined that group. Now, an employer can still ask an employee to verify, in verifying compliance with age requirements. That's okay, but you can't, put that in your job application and whatnot. And then, so just kind of keep this in mind. It's always better to just leave out social security numbers from job applications, date of births, all of that kind of stuff. You can, of course, you will get that information later once a job has been offered to the person, because you need it for federal forms like the I-9 and whatnot. But we just, it's just about not having it on the job application. Now, if anybody has any questions and they need job descriptions, template, interview questions, anything like that as you're hiring, let us know, and we at HR for Health can give you some really good samples of that. Okay, New York City, employers in New York must provide a copy of the city's Workers' Bill of Rights to all of their existing employees and any new employees that they hire. Okay, and then on top of that, you also have to post it somewhere in the office that's easily accessible to the employee. So usually like a lunchroom or where you have your posters and things of that nature. This actually went into effect in March 2024. So if you don't have one, let us know. HR for Health sends to all new customers a physical set of posters, and then some of our premium clients, they get a little bit more support on that front. So let us know if you need this information. If you don't have it, again, super important. There's a QR code on your screen where you can download it as well. If you have any trouble with this, let us know. Okay, all right. Oregon has made a change to their paid family leave and medical laws. And so the new law now, changes a couple of things, right? So it changes how benefits are calculated, who qualifies as a family member. It reinstates some employee rights, after protected leave. And then it talks about when an employer has to continue an employee's benefit. And then, can some of these benefits run concurrently together? And so again, Oregon's getting pretty complicated, right, with their Oregon Family Leave Act. And so just kind of know that it's important to ask questions. If you have any employees who are going on leave, call our support system and we'll help. But their main goal for doing this was they wanted to reduce inconsistencies and redundancies in the two laws that they have, which is their paid leave laws, and then what they call their Oregon Family Leave Act law as well. And so again, kind of confusing, but their goal was to reduce the redundancies. Some of their medical reasons, qualifying reasons for taking leave, have been expanded. They kind of clarified some interactions between leaves of the two laws. They did decrease the bereavement leave under the OFLA, so that's important to remember. But most of, for the most part, they've expanded and organized these changes, these 5 changes that I just went through. Okay. All right. Chicago has changed their paid family leave ordinance. They had a paid sick leave law, like many states are starting to implement. And they've sort of modified it now So on top of including, paid sick leave entitlements requiring up to, I think it was 40 hours of accrued paid sick leaves for eligible employees, the new law allows them to basically have an additional 40 hours during any 12-month period, effective July 1. And so what's important to remember is that when it comes to rules like this, especially with PTO, paid sick leave, and things of that nature, it's really important to have a electronic system that allows you to not only set up the time tracking and time off policies, but that is tied to clocking in and clocking out, right? Because everything is tied to when your employees clock in and clock out. And so having one clock in, clock out system and then having other system doesn't always, work so well. And so we highly recommend using HR for Health system for this, so that one, the information is available in real time to the employees, which is the law in many states, including Chicago. But more importantly, it's available to you as the employer when you need it as well. Right now, why are we talking about this? Because it's not obviously just Chicago, right? This is happening in so many states. In fact, 17 states and Washington, D.C. have these sort of mandatory paid sick leave laws. They have to be tracked, like I mentioned, in real time. California's sick leave law was expanded. And so we're expecting all, if not most, of the states to have their own sick leave laws, soon. If not, guess who's going to get into the game? The federal government's going to probably get in and put something together for everyone, right? For everyone. So just kind of keep that in mind. All right, Maryland, there's a new law signed by Governor Wes Moore on April 25th. And basically, there's a couple of very important things. This, Maryland, we talked about the non-compete law that the federal government had. Well, Maryland already has, and already bans non-competes as well for employers earning 150% of minimum wage or less. This adds a little bit more restrictions for licensed veterinary professionals, actually. And so again, they're going beyond what the federal ban is by putting it specifically on veterinary, professionals, and then other healthcare professionals as well, who are earning, let's say, less than $350,000, potentially, have, some restrictions. And if they are making more than $350,000, then the non-compete is limited to 1 year or 10 miles from their primary place of employment. So again, getting in really heavy-handed, in terms of and being very detailed about what can and cannot be done as far as non-compete. So my advice is, and I know some of this can be confusing, my advice is have your employment agreements reviewed by me or someone like me to make sure that they're compliant with Maryland law. And regardless of where you are around the country, have us take a look at it and make sure you are compliant. Okay, so lots of stuff happening, as you can see. This is a summary of all the rules and changes that have happened mid-year. Some of these, which we've of course talked about. We at HR for Health launched in January what we call the employee scheduler. It makes sure that your employees are informed on when they're working and when they're not working. It gives you a really great view of where your employees are, where there's gaps, and how you can fill it. So again, please use that tool. It's an incredible tool. And it allows you to better schedule, keeping your budgets sort of in mind, and also filling gaps, especially with, providers where, who are billing patients. It's going to be huge benefit. Here's some more states with, various employment law updates. If you see your state on here and we didn't talk about it today, just reach out to our team. We will, of course, answer any questions you have and take great care of you. So the question really now is, all right, well, what do we do next, right? Like, how do we implement these? How does it impact professionals? Well, for all of you who are practice owners, you know that this is impacting your day-to-day at a very high level. And so it's really important to review and update your policies, making sure you're compliant with, with all the new federal and state guidelines, incorporating your harassment policies, data privacy, wage policies. I mean, it's all, things that need to be done in terms of policy updates. Then there are some training requirements, and implementing regular training is sometimes really hard, especially for your team, and having documentation of those, again, hugely important. If anybody needs help on that, let us know. And then finally, and probably the most important, is making sure you've got great documentation and record keeping of everything you're doing from an HR perspective. Keeping meticulous records that don't get destroyed, which is why we, created HR for Health, is your, get out of jail free card. Because no matter what happens, right, whether you lose your HR person, or maybe you are the HR person, you don't want to do it, or you forget, no matter what happens, that data will always exist in our system, and you can always use it, to protect yourself. And so again, hugely important. We absolutely, believe in documentation and then and compliance. And so, which is one of the reasons why we've created all these tools to make sure that you are compliant, not just with the documentation requirements, but also from all the other rules having to do with wage and hour, non-competition, and leave laws as well, especially with people on pregnancy and otherwise. Okay, so what do you do now, right? What should we do next? Because there's so much to do. And what I have found, flying across the country, lecturing to thousands and thousands of people, talking to employees at your practices, having people come up to me, is that there's this expectation, right? There's this expectation that that the employees have that sometimes surprises business owners. And that expectation is summarized like this. We know that in this day and age, everything is available at our fingertips. I show this slide because when you, and many of you are, subscribers to Amazon's Prime, when you want to order something, it is minutes away, right? You have to be on your computer or your phone. You can order almost anything you want. It'll get delivered to you in a couple of days. You know where it is. You know when it's going to arrive. You know how to return it. You know everything about it. Everything about it. And employees have that same expectation about their employers, right? They want their employers to be equally transparent with them. They want to have the same information. They want to know, when can they take time off? What are their paid holidays? How much PTO do they have? What's their salary? When's their performance reviews happening? What happened in their performance review? What do they need to do to take the next step to grow? All these things are things that employees are demanding. And I think there's this thought process that employees don't want to work hard. Well, that's not what my experience is. Not at all. My experience is that employees, for the most part, want to work hard. They're okay working hard. It's challenging for them, right? They enjoy it. What they don't like is what I call bad stress, right? And bad stress are things that they can't control, right? That's not having information at their fingertips about what their benefits are, not knowing if, when they qualify for healthcare, 401k benefits, not knowing kind of what's happening with their job. These are bad stresses that impact their experience in your office. And so what I think our target should be, our goal is to have an Amazon experience for our employees. Let's make sure we are super transparent with them and we give them everything that they need at their fingertips while keeping ourselves safe, in a compliant way. And that's what HR for Health is all about. And so what I hope is that you don't hide from this, that you use this as an opportunity to want to grow And what you will find is that it's just small steps, right? It's just small steps. The first thing is to contact the team and maybe do an HR audit, maybe get a new employment manual and things of that nature. And then from there, what you'll see is that you'll start kind of getting in a groove and a certain cadence, and then suddenly, you're getting compliant all the way throughout by giving everyone the new hire documents they need, and so on and so forth. And our software has been created with you in mind, of course. We'll give you automated updates on your employment handbook. No doubt about that. You never have to worry about being compliant with the handbook anymore. We give you a custom handbook, that our team works with you to create. We give them, reminders about lunches and breaks, overtime. If employees are tardy, we'll give you those. We'll give you absolutely everything. And because our goal is to make this as simple as possible so that you can focus on your patients and not necessarily worry so much about the HR side. And of course, this was a law update, not necessarily all the legal things that you need to do on a day-to-day basis. But that's where our HR advising team is available to you. And so if you are interested in learning more about HR for Health and to see if it's a good fit for your office and to see kind of where you are and what you need to add to be compliant, where the gaps are, just go ahead and scan this QR code on your phone, and you can set up a time to chat with one of our team members. It's sort of a no risk, no pressure tactics, no obligation type of conversation about what's going on, and they will kind of dig deep a little bit on kind of where you are and how they can help you get compliant and answer any questions you have. All right. Well, thank you all for attending. I hope you enjoy the rest of the year. And again, remember, we are here to support you. So please reach out to us at any point if you have any questions. We'd rather you ask us questions than make a bad decision with your HR. All right. Thank you, everyone. Have a great rest of your day.